Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because you know, on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it, and all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous. Okay? All right. Let me, thank you. Good morning. Are you Stephen, is it Bodwin?
Bodwin.
Bodwin.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Bodwin, in cause number 25, DCCR 0940, and so count 1 only, and then to the lesser attempted, correct?
Correct.
The state's elected to proceed on count 1 only, and in count 1 to the lesser offense of an attempted robbery. That makes it a 3rd-degree felony, and that's from June 24th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State Tenders Number 1.
No objection.
It's admitted. Any evidence that Mr. Bodwin is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and then we'll come back later for sentencing. Miss.
I think he may have a parole issue, Judge.
He does.
We need to check on. In my read of this, if this is the only thing he's dealing with parole, and my experience with parole, I don't anticipate that they would probably revoke him based on these underlying facts.
Okay.
I think it would be best if we
Okay, just leave everything the same.
information we can get, and if we need to withdraw this and plead to something else, we can.
Okay, yeah, and if y'all can look into that and see if parole, have they already been out for a hearing?
Yes, ma'am. I had a revocation hearing on August the 19th, and they chose to reinstate my parole.
Okay,
But then on the 2nd, she gave me a new violation for the same allegations that I'm dealing with.
Okay.
Same exact allegations.
Okay.
They just voted on the revocation.
so they voted to revoke now, or
No, they haven't voted on it.
they haven't done it
They
yet?
did vote, and then in the same instance, she
Right.
gave me a new violation report.
Do you know when they're coming, you have no idea when they're coming to do that
I was
again?
scheduled for a hearing last week, and she didn't show up.
Okay, if y'all will work to see maybe when that's gonna happen so that we know, obviously if they're gonna revoke you, it doesn't make sense to put you on probation. If they're not, then we can go forward with this, but we'll find out before sentencing. Okay, you can go back with the bailiff. Good morning, you're Logan Eagleman?
Yes, ma'am.
Let me get this. Mr. Eaglin, in cause number 25 DCCR 0897, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from October 26th of 2024. Your indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, March 1st of 2013, in 2 cases on that same date of burglary of a habitation. And then after those were final, you were convicted of possession of a prohibited substance in a correctional facility, a third-degree felony, from September 3rd of 2015. What that means is that if you go to trial and you're found guilty and those prior convictions are true, you would be considered a habitual offender. The minimum punishment would be 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 20 years in prison, which means if you did that, I'm guessing that would be to just count 1 only. So you would only be pleading to the offense that you're charged with. And the most I could give you is 20 years. I could give you 20, I could give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to reject that offer and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, is there any reason to believe that that offer would change, Mr. Smith? So I do want to make sure you understand, Mr. Eaglin, that after today, unless there is new evidence that comes up that the attorneys don't know about already, I will not accept this a plea agreement after today. Once your case goes on the trial docket, it either, if you plea, it's just something different, or we're going to let a jury decide. You understand?
Yes, ma'am.
All right, so we'll get it set on the trial docket. Mr. Eaglin, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Lewis, you are released. We will appoint someone today, Mr. Eaglin.